There's a,
There's
see that
probation is
the very
not.
last, there's a recommendation of probation, but there's no.
It's in there.
Take your time and look over it when you have a minute. Let the record reflect state's attorneys present, defendant, and defense counsel are present. Are you both ready to proceed with punishment? Are you ready, Mr. Burbank? You can bring the jury in.
I see.
Here's an extra copy.
Did I make any notes on this one?
Yep.
Let me get that back.
It was, all. Unfortunately, yeah.
The ones that I gave you, yeah.
Right, I mean, no others.
I don't know. Oh, I've got, this is the only one I'm focusing on from March 21st, 2026.
Just what you have to say, I go both sides. These.
Good morning. Let the record reflect the jury seated, state's attorneys present, defendant, and defense counsel are present. Mr. Coleman, does the state wish to make an opening statement?
No, Your Honor, state would waive it, okay, said.
All right, you may call your first witness.
Before I do that, Judge, I re-offer all of the evidence from the guilty phase into the punishment phase, Judge.
All right, that's granted.
State this time would call. Michael Ponder. It is not being selected.
Thank you. Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. You can have a seat. You may proceed.
Make sure that your rank right, Mr. Ponder. What is your rank?
Captain.
Yeah, Captain Ponder. Thanks for being here, Captain Ponder. I know we reached out to you somewhat on short notice. Please state your name, full name for the court reporter and for the ladies and gentlemen of the jury.
My name is Captain Michael Ponder.
And how are you employed, sir?
I am the captain of the Jefferson County Sheriff's Office.
Okay. And your duties as the captain at the sheriff's department, what does that include?
I am the custodian of records. I'm responsible for keeping all of our records for the state required time.
Very good. And would that include or encompass the booking records?
Yes, sir.
I'm sure the jurors are familiar with that term booking, but let's just play it safe. What does that mean? When someone is arrested and brought to the jail, in summary, what happens?
When anyone is brought to jail, we collect all of their personal identifying information and all the causes for them to be confined in the jail.
All right. And that personal identifying information includes date of birth.
It'll include their name, date of birth, pictures
Photos of actual photos
of the individual. Yes,
of the
sir.
individual as well. Do you have any reason to believe that that process did not take place with the defendant here, Asa Jones?
No, sir.
In fact, would you bring with you some records related to Asa Jones?
Yes, sir.
May I post the witness, Judge?
You may.
May I see those, please? Are these records, I think what I want to just focus on is this first page. I'll let you keep that. This page, is this a true and accurate copy of the records that are maintained in the ordinary course of business by the Jefferson County Sheriff's Department?
Yes, sir.
All right. For the record, I am going to mark this judge as State's Exhibit 74. And I will tender to defense counsel for his inspection.
Okay, I have a couple questions, Ron.
This is,
Good morning. Did you generate this report?
No, sir.
You're just the custodian of the record.
Yes,
You have no knowledge of how this was entered or anything to do with this state's exhibit 174.
no, I'm aware of how the process we use when it's done, but I did not create that myself.
But you did not do this. Subject to hearsay, Your Honor, I have no objections to it. If he's going to testify to any personal matters in this document.
Just let me, if I may, just follow up with the full break it on that. Whoever entered these entries on these or for these records would have done it at or near the time when that information was provided to them, correct?
Correct.
And it would have been done and maintained as part of the ordinary course of business for the Jefferson County Sheriff's Department, correct?
Yes, sir.
That's I believe I've laid the proper foundation of preparation.
I still have the same objection, Judge, if he's going to talk in reference to knowledge of that information. I have no objection that that's a record that's kept in the normal course of business. But anything behind that, I object.
Any hearsay in a business record is an exclusion or exception to the hearsay rule.
I guess I'm not understanding the objection because you're not objecting to the piece, the
I'm not
actual
objecting
document
to-
coming into evidence.
Objecting to any of the facts or circumstances surrounding the entry of that information, that he's going to testify as to any knowledge of what the circumstances were, book in, or anything about if there was a charge or anything like that behind those records. I'm not objecting to that.
So no objection to say 74.
Well, it's subject to if he's going to go into. the
Well, then
contents of-
object if there's a question. I just need to know if there's an objection to 74.
No, I told you there was no, yeah. Judge,
That's what I need.
there's no
I'm
objection to
confused.
The document. It's
Okay, 74 is admitted. And then if there's another objection, if you ask a question, just make it then so the record's clear.
Thank you, Your Honor. Captain Ponder, for this individual, what's the name listed in that record or document for him?
Asa Joseph Jones,
Okay, and a date of birth for that individual?
February 16th, 1999.
And is there a photo included for that individual?
Yes, sir.
Do you see someone in this courtroom today that resembles the individual depicted in that photograph?
Yes, sir.
Would you please point to him and identify him by an article of clothing that he is wearing?
So gentleman, I believe it's gray shirt.
Your Honor, I'd ask that the record reflect that the witness has identified the defendant.
The record will so reflect.
That's all the questions I have. I'll pass the witness.
Thank you, Mr. Coleman. Any questions, Mr. Coleman?
No questions.
Any objection to Captain Ponder being excused?
It's under the rule.
Thank you, Captain Ponder. And you are placed under the rules to not discuss anything with anybody until the trial's over.
Yes, sir.
All right, thank you, sir. You may call your next witness.
The state calls Steve Hinton.
Oh, you want to step right out real quick and check? I'm not real sure that Deputy Williams heard us. That's right. They said
It's like we need to take it, we're just out of order.
if he's walking down, we can wait just a second.
No, State calls Sergeant Marlon Carter.
Okay. Good morning, sir. Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing or this trial will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can have a seat.
Sergeant Carter, would you please state your full name for the court reporter and the ladies and gentlemen of the jury?
Marlon Carter.
And Sergeant Carter, how are you employed, sir?
I work at Jefferson County Correctional Facility.
And were you working back at the Jefferson County Correction? Well, in what capacity do you work there?
I'm a sergeant, a supervisor at the correctional facility.
Okay.
Can you pull
And
that microphone down just a little bit? There you go. Thank you, sir.
were you working there back on March the 21st of 2026?
I was.
And at around 12:30, what, if anything, caught your attention? And I want to be careful not to get into hearsay. In other words, what someone other than the defendant said. So, but describe to the jury what caught your attention.
I was advised by my fellow officers that an inmate was refusing to go back into the holding cells at the recreation yard.
Let me stop you right there. Did you make contact with that individual, that inmate that was refusing to go back into the holding cell?
I did.
And again, I don't want to get into what he told you because it's hearsay. But as a result of what he told you, did you then go and pull Asa Jones out of his cell?
I did.
And did you bring Asa Jones back to your office?
Yes, sir, I did.
And did you speak with Asa Jones about whatever issue it was that the other inmate had, which was causing him not to want to go back to his cell?
Yes, sir, I did.
Now, you certainly can say what the defendant told you. That's not hearsay. So at that point, what did the defendant tell you?
That he admitted that he had thrown a substance on Mr. Franklin
A substance believed to be what?
to be urine.
Okay. And unfortunately, is that a common or uncommon occurrence out there at the jail?
It is a very common occurrence.
Is there like a term that's referred to that?
Dashing.
Dashing.
Yes, sir.
It's not uncommon for inmates to dash other inmates, and it's not uncommon for the inmates, unfortunately, to dash correction officers. Correct?
Yes, sir.
To dash a correction officer, that is it's a felony, if not mistaken, right?
Yes, sir.
And that's not limited to just urine, unfortunately, right?
No, sir.
Other bodily things, correct?
Yes, sir.
All right, but with regard to other inmates, at a minimum, is that a violation of the jail rules or guidelines out there at the jail, right?
Yes, sir.
Something for which the defendant would have known or defendants are advised is not allowed or not appropriate, right?
Yes, sir.
Okay. Pass the witness charge.
Thank you, Mr. Coleman. Mr. Burbank?
Yes. Good morning.
Good morning.
You can remember, Deputy, what cell or what dorm was Asa in?
I do not recall the time.
Okay, how many people were in that dorm approximately?
It was on the recreation yard, so the whole population was, usually the dorm holds one to 48 inmates, so the whole population was outside.
And when you say the whole population, the whole dorm population?
Yes, sir.
Okay, so 140, 150 people,
No, sir, just that 48 inmates.
48 inmates.
Yes, sir.
Okay, I thought you said 140. Okay. So 48 inmates in a dorm.
Yes, sir.
In the dorm, you take the dorm out at the same time into rec.
Yes, sir.
And rec is, let's get them outside and whatever they want to do, exercise and things like that.
Yes, sir.
And this dorm, is it one big room?
Yes, sir. It's a holding, like a rec pen outside.
Okay, so it's a rectangle building and it has beds in it and bunk beds, right?
The fencing outside for.
No, I'm talking about the dorm.
Yes, sir.
You have the 48 people in one dorm, one big room, common bathroom,
Yes,
right?
sir.
And bunk beds.
Yes, sir.
And so they're all in there, right?
Yes, sir.
And these people that are in there, charged with all types of crimes,
Yes, sir.
offenses, right?
Yes, sir.
All walks of life.
Yes, sir.
They're kind of like in a cow pen. I mean, they're all in one building and have to deal with each other 24 hours a day.
Yes, sir.
And I know this is a correctional facility, so I understand that. Now, you received information in reference to Asa and another inmate in reference to a conflict that started out in the rec yard, correct?
Yes, sir.
And you would agree with me that tensions usually do run high out at the jail facility, correct?
Yes, sir.
Because of the overcrowdedness, right? I heard the other day, I don't know if you heard it, that the sheriff said we may need an additional jail because they were going to be overcrowded. Did you hear that?
Yes, sir. I did.
Oh, okay. So your sheriff said, your boss said,
Yes, sir.
we're kind of overcrowded, right?
Yes, sir.
Okay. And but in addition to that, you have 40-something men all together, all different walks of life that have to stay together, right?
Yes, sir.
And so conflict is common, isn't it?
Yes, sir.
People don't get along.
Sir.
And what you heard, or excuse me, did you ever in your investigation look to Asa that Franklin originally or started, he had thrown something at him.
Yes, sir.
Right? So he threw something, he thought it was water, but he didn't know what it was, right?
Yes, sir.
And so in return, Asa threw something back at him, right?
Yes, sir.
And when you brought him out and separated the two,
Yes, sir.
right? You were called in, you brought him to another location,
Yes, sir.
right? And you talked to him, right?
Yes, sir.
Of course, now the other inmate wanted to press charges, right?
Yes, sir.
I mean, when he started it, right?
Yes, sir.
Okay, well, charges pressed.
I do not know.
Okay, but you didn't press any charges.
No, sir.
You didn't write a report that says I'm pressing charges.
I added it in my report.
Yeah, but that you wanted to press charges.
Yes, sir.
That was it. And my question, Deputy, is you didn't then follow up with a criminal offense and say, I recommend criminal charges against Asa.
I don't handle that department. That goes to somebody else.
Okay. And so when you brought Asa in, he talked to you, right?
Yes, sir.
And he didn't try to say, I didn't do anything right. He admitted to it, right?
Yes, sir. He did.
And he said the reason why was that somebody else had this other gentleman that he had conflict, ongoing conflict, I guess, with that started about 2 weeks prior, correct?
Yes, sir.
Okay. And I guess it escalated.
Yes, sir.
And then after that, you brought him, who's Sergeant Granger?
Another supervisor on the unit
Okay, why would you bring him to another supervisor?
to confer a good outcome of the situation.
Okay, so I mean, he then followed your orders
Yes, sir.
and went to wherever you said and talked to the other supervisor, right?
Yes, sir.
And then after it all was said and done, you sent him back to the door.
Yes, sir.
That was it.
And wrote a disciplinary case.
Yes, well, you wrote up, okay, well, did you put him in segregation?
No, sir.
Right? Did you take away his privileges or is there any?
We did a disciplinary case and then a disciplinary board served him his disciplinary case.
Okay, but you don't know anything about the disciplinary case?
No, sir. I can't take process of that.
But you didn't segregate him, you didn't put him in lockdown or solitary or anything like that. You said basically, you gotta stop this, whatever it is, and you sent him back to his door.
Yes, sir.
Thank you. Pass witness.
Thank you, Mr. Coleman.
Sorry, I just want to clear up something. The defendant himself admitted that the substance that the other inmate threw on him was water, right?
Yes, sir.
All right, so he admitted that at some point prior to him throwing urine on this other inmate, the other inmate only threw water on him, correct?
Yes, sir.
All right, pass witness.
Thank you. Anything else, Mr. Barbe?
Well, that's what he thought it was water, right? That he said, yeah, I think he threw water on him, right?
Yes, sir.
Okay.
All right, any objection to Sergeant Carter being excused?
Okay.
Thank Thank you, Sergeant. You're excused.
State will try to call Steve Hinton again, Judge.
Investigator Hinton.
Investigator Hinton.
Good morning. Please raise your right hand. You swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir. You can have a seat.
Would you please state your full name for the court reporter and the ladies and gentlemen of the jury?
Stephen Russell Hinton.
And Investigator Hinton, how are you employed, sir?
I'm employed with the Jefferson County District Attorney's Office as a criminal investigator.
Okay, and prior to being employed with the DA's office, what is your background? Do you have other law enforcement background?
Yes, I have about 42 years of law enforcement experience.
Including what agency?
The Groves Police Department and the Jefferson County Sheriff's Office.
Okay, and have you had any training as it relates to fingerprint or fingerprint analysis?
I have, yes, sir.
And please tell the jury what that consists or consisted.
The District Attorney's Office sent me to a class, a school in Garland, Texas. It was Texas Forensic Associates, where they went through a battery of training comparing prints, well over 1,000 of them for the week, to be proficient in identification of prints.
Okay. And also, in addition to going to your training, have you conferred with or had any additional guidance by other investigators in the office who've been identifying prints for some time, quite some time?
Yes, we use the ACE-V methodology and verified with Paul Arvizo, another investigator in the office.
The ACE-V methodology, is that just a kind of the technique or underlying method?
Yes, it's an underlying method we utilize to make the comparisons.
Okay, and just briefly, what does that mean?
It's to analyze, compare, and evaluate, and then we verify with another agent of greater experience, I guess you would say, to confirm that what I'm looking at is in fact the same thing that he sees or she sees.
And does that ACE-V methodology include looking for those points like the jury heard from the other ID techs previously in this case?
That's correct. Points or characteristics, however they want to call it.
Okay. I mean, and what is the point? What are we talking about there?
We're talking about either bifurcations, ending ridges, dots, deltas, whatever the actual print presents itself to.
Okay, and just to be clear and make a pretty good, the record better, I should say, fingerprints. I mean, we all think we know, we all have an idea of what they are, but essentially, how is a print left on? How does a print go from someone's finger or hand onto an object?
Scientifically, they're called friction ridge skin. They're located on the tips of your fingers, on your palms, as well as on the sole of your feet. That's the only three places they're located on a person's body. Oils from your hands, from your hair, from other things that you may get, you transfer a print to another object by touching it and transferring it to another object, which is either paper, glass, or something that would be something that would actually receive the print without too much distortion.
Have you ever known or heard of two individuals to have the same or exact same friction ridge scan or fingerprint?
No.
In this particular case, did you take what's known as an inked print from the defendant Asa Jones?
I did this morning, yes, sir.
And what is an inked print?
It's where you apply ink to a friction ridge skin. In this particular situation, it was the right thumb, and then you transfer it to a fingerprint card for comparison.
And you kind of alluded to my next question. What, if anything, did you compare that ink print or ink prints to? What were you taking that print from him to compare it to?
To previous judgments from past history.
Judgments that resulted from previous convictions or adjudications of criminal offenses, right?
Yes, sir.
And those judgments or adjudications, they typically have prints on them that identify the individual who was convicted in that crime or adjudicated of that crime.
They do.
Sometimes, is it fair to say?
Hold on a minute, Tom. Can we approach Judge? Go on.
That's why.
Oh, oh, record for a second. They gave me notice. I just. Oh, the records. Oh.
We talk about judgments, judgments typically contain fingerprints. It's not unheard of for certain judgments to not have a fingerprint at all, correct?
Sometimes the way they store them, they pixelate them to the point you actually can't read them anymore.
And I was gonna get to that, but you have heard that some jurisdictions, particularly with misdemeanor offenses, they don't even put a print on their judgments, right?
That's true. Yes, sir. Some of the rural areas.
Yeah, so there could be judgments without a print, and there could be judgments with either distorted or somehow an issue or defective print on it, right?
Unreadable print. Yes, sir.
Unreadable print. And in those instances where there is no print, where there is a print that's unreadable, is it possible to use other identifiers to link an individual to that judgment?
It can be. Yes, sir.
And we're talking about identifiers like date of births or what's called a SID number, state ID number, that kind of thing.
That's correct.
In addition to the name that's on the judgment, correct?
Yes, sir.
Do you have judgments here today that you believe are associated with this defendant?
Yes.
No, I'm sorry, Judge, may I approach?
Yes, sir.
I think what I'm gonna do is I'll mark this first. May we approach, please? All right, investigator Hinton, let's go through these one at a time. The first thing that I have marked is states exhibit number 75. Is this a copy of the inked print that you took from the defendant?
Yes, it is.
Okay, they're the same, it looks to appear to be in the same condition as it was when you originally took that print.
It's identical, yes.
Okay. And we also have here some judgment information that has been marked as it will be 6, 7, 78, 79, and 80. 76 through 80 that I've marked. Now, the issue is it fair to say that when judgments are requested, they don't just, clerk's office doesn't just give us judgments, right? They give us a lot of other documents to go along with it, right?
The packet, yes.
And those documents are all certified together. So to remove them and separate them apart will be kind of like messing with or kind of the argument could be made that they're no longer a certified document if you start separating them outright.
That's cool.
And I represent to you that there's an agreement between the parties here that we can now separate these. In other words, just take the judgments out. So I think that's what we'll do one at a time, okay?
Okay.
Let's start with state's exhibit number 76 here.
Your Honor, if he just separates it out, I think even if he separates the document out, it's still a certified copy. He's not tendering a non-certified copy, and instead of going all through this, there are documents in there that have to be taken out. He just take it out and present it.
I'm good with that. If there's no objection to that, go ahead, Mr. Coleman.
All right. You're at this time, the state office states 75 through 80. And I'm tendering to defense counsel for his inspection.
Objection states 75 through 80 conclusive.
States 75 through 80 are admitted.
All right, investigator, I'll put these here so we can take them one at a time. Let's start with state's exhibit. Number, well, let's do it for this order. Correct order 76, 77, 78. Can you start with this one? All right. What is the cause number there at the top?
House number is 23 CCCR 2496.
And it's a judgment, correct?
Judgment of conviction, yes, sir.
For what offense?
Unlawfully carrying a weapon.
Unlawfully carrying a weapon and that's a misdemeanor, right?
Yes, sir.
Okay. And what, if any, ways or methods did you use to link that judgment to this defendant? Well, let's start this way. What condition is the print or the fingerprint on that judgment?
The print was at extremely poor condition. It
Okay,
was pixelated to the form that you really couldn't read any characteristics or points from it.
I
To
see.
utilize the prints as identification.
All right, but nevertheless, it has a name and the name on that judgment being,
Asa Jones.
and it has a date of birth on that judgment, the date of birth being. Well, I separated the paper, the certification from it. It's on the certification. May I quote the way research?
Yes, sir.
Certification for it. Just verify the case number, is it the right case? It's not. Yeah, here we go. This is the right. It to be either C or any of the other, is it the state of records? Is there a complaint or an information in that packet?
Let's do this, ladies and gentlemen. It's 9:45. We're going to take a 15-minute break. If you'll please keep in mind all the instructions that were previously given. If everyone else, please remain seated. You're excused for 15 minutes.
It's different. So
Here, no, here's it, right here on complaint, same cause number, date of birth.
All right, I'm going to give y'all some time to get that worked out so we can move at a better pace when I come back in. Court's in the recess. Okay, let the record reflect state's attorney's present, defendant, defense counsel are present. Let's get the jury back in. You may proceed.
Thank you, Your Honor. Investigator Henry, before we go, so we're talking about the unlawful carrying of a weapon conviction appearing in cause number 23 CCR 2496. And your testimony was with regard to the print on that judgment. What condition was it in?
Yeah, it was a poor print, unreadable.
And were you able to use other identifiers to link this defendant to that judgment?
Yes, sir.
Those identifiers include what?
His name and his date of birth.
Okay. That date of birth being
Uh,
2/16/1999.
that's correct.
And may I proceed with your search?
You may.
Is that consistent with the name and date of birth that appears in State's Exhibit number 74, the booking records for that defendant?
Yes, sir, it is.
And that particular judgment for the misdemeanor was from, what's the date of the judgment, if you can find it there?
Date imposed is 8/7/24.
Okay, and what, if any, punishment did the defendant receive?
Shows 1 year probation.
All right, so he received 1 year probation on that unlawful carrying of a weapon in August of 2024. Let's move on to the next judgment. That was states, what was that marked as?
State Exhibit 76.
76. Let's move on to 77, please.
Right.
What's the cause number that appears on that particular judgment?
It's gonna be number 329698.
And that's what offense? What offense is that a conviction for?
It shows unlawfully carrying a weapon.
So we've got another unlawfully carrying a weapon from what's the date of that judgment? What date was it filed with the clerk if you can't find the date of the judgment?
August the 22nd of 22.
Okay. And what, if any, punishment did the defendant receive for that additional unlawful carrying of a weapon?
It shows 30 days confinement.
Okay. Let's move on to State's Exhibit number 78. What's the cause number for State's 78?
Number 312936.
For what offense?
It's gonna be possession of marijuana, Class B.
And from what's the date of the judgment?
It's gonna be November the 1st, 2016.
And what, if any, punishment did that defendant receive?
5 days confinement.
You know what? Let's back up to 77. I neglected to ask you with regard to 77. How did you link that to him, to the defendant? States 77 being that additional unlawful carrying of a weapon. Was the print good on that one?
Yes,
Did you use that to compare to your inked print?
to my known print, yes, sir,
What, if any, determination did you make?
that they are one and the same.
And in addition to comparing the prints, they also contain the same identifiers, date, birth, and the name of the defendant. Right?
That's correct.
Okay, all right, put that to the side. Let's get back to 7A. The judgment for the possession of marijuana. I don't know if we established it or what, if any punishment did you receive for that?
5 days.
And how did you link that to the defendant?
That print was also of good quality and I was able to make the characteristics comparisons and showed it to be one and the same.
Okay, very good. And in addition to the print comparison, I also had the same date of birth as the other judgments and as the booking records, right?
That is correct, yes, sir.
Now let's move on to State's Exhibit number 79. Is that cause number 327534?
Yes, sir.
And what offense does that refer to?
Unlawfully carrying a weapon.
All right, so third, unlawful carrying of a weapon.
Yes,
What, if any, punishment did the defendant receive for that offense?
it was 30 days confinement.
And did you, was the print of good quality and were you able to compare it to your known inked print?
Yes, it was good quality.
And what, if any, determination did you make?
that they are one and the same based upon the known print.
Very good. And lastly, states exhibit number 8. That a failure to ID judgment.
Yes, failure to identify.
And does that have the case number, cause number 313216?
Yes, sir, that's it.
And for the ladies and gentlemen of the jury, failure to identify, that is a criminal offense. Typically, how does that occur?
When he's encountered, he's asked for identification and they give false identification.
Encountered by law enforcement?
Correct.
Okay, all right. And that particular judgment, what, if any, punishment did this defendant receive?
It shows 1 year probation.
Okay, so another year probation, correct?
Yes, sir.
And what, if any, method did you use to link that judgment for the failure to identify himself to this defendant?
The fingerprint again was good quality to be able to make the comparison to the known print.
Okay.
As well as the name and the date of birth on the documents.
Very good. We'll just get these exhibits over there, Judge, and I'll pass this.
All right, thank you, Mr. Coleman. Mr. Burbank?
Yeah, sure.
Morning.
These offenses that you just testified to, investigator, are all misdemeanors, correct?
That is correct, yes.
And the first one. This was, what year was that? Don't remember.
22 or 16, I'm sure.
Approach judge. And state exhibit number 76. That was in 24, correct?
Yes, sir.
And he's got,
24.
he's on probation, correct?
Yes,
And 77, states exhibit number 77. That was, in August of 22, correct?
that's correct.
And when it says 30 days, does that indicate possibly to you through your experience that it appears he was represented by counsel, correct?
Yes, sir.
And that he was just time served? Is that what it appears to be?
It's a possibility, depends on how long he was
Right.
in jail.
And that's not unusual.
Don't talk over.
Sorry, that's not unusual in a misdemeanor case, correct?
Sure.
Okay. And then, states exhibit number 28. I mean, excuse me, 78. What date was that on?
November the 1st, 2016.
Okay, and he got 5 days for that?
Possession of marijuana, yes, sir.
And that, does that also look like a credit for time served, 5 days on a misdemeanor?
Could have been, yes, sir.
I just want to get it over with. He's been sitting in jail. You can answer.
Could have been.
Okay. Were some of these related from the same offense? You talked about a failure to ID. Was that related to another offense that you just talked about?
I think it might have been the possession of marijuana case.
Okay, so he possibly could have gotten arrested at the time and asked him for his name, and either he didn't give the right name or didn't want failure to ID, but that was all associated with the same case, correct?
I believe so, yes, sir.
Okay. And the same way with State's Exhibit number 79, which was, well, this is August of 22, right?
Yes, sir.
And State's Exhibit number 77. That's the same date?
Same date.
So he just took care of two cases at the same time?
It does appear that way.
Different cause numbers though, right?
They are.
Awesome. And there appears to be possibly that he was represented by counsel, right?
Yes, sir.
Under counsel's advice.
Correct.
And then this last one. Um. State's Exhibit number 80. That was the failure to ID, and that was the one that was, you said, went along with the possession of marijuana. That sound about right?
I believe so, yes, sir.
Okay.
1 year probation.
Prior to court today, in order to do your comparison, which is State's Exhibit number 75, which you identified as his prints. You did that here, did you not?
I did, yes, sir.
He was cooperative,
Yes, sir, he was.
um, and didn't give you any problems.
No, sir.
And at any time, do you have any knowledge in reference to all the exhibits here, 76 through 80? Um, Did he ever deny any of the prior offenses to you?
No, I never did interview him.
No, but he never said that wasn't me.
No,
And he was cooperative in an identification, right?
yes,
Yeah, and I say that because you went through an elaborate of how to identify him either through his date of birth, his name, or usable late. That's correct.
yes,
I mean, he never said that's, I'm not Ace Jones in this.
no, no. In fact, he signed the known card.
And it's safe to say you know nothing about the offenses that are in State's Exhibit 76 to State's Exhibit 80, do you?
That's correct. I'm just comparing.
Just comparing fingerprints.
Prints and identifiers to determine if they're one and the same.
Thank you, investigator. Fascinating.
Anything else, Mr. Coleman?
No, sir.
Any objection to investigator being excused?
No, sir.
Any objection? Thank you, sir. You can step down.
State calls Jody Roach. So recalls Jody Roach.
Good morning. And Ms. Roach, you're still under your oath. You may proceed.
Thank you, Aaron. Thank you full name for
Jody Roach.
Jody, Ms. Roach, you work for the probation department, don't you?
Yes.
We made an effort to make sure that that wasn't put out there during the guilt innocence phase so that it wasn't prejudicial to the defendant, right?
Correct.
All right. Nevertheless, this defendant was being supervised by the probation department back on June the 12th of 2025, correct?
Correct.
For the offense of unlawful carrying of a weapon, right?
Yes.
Please tell the ladies and gentlemen of the jury the nature of his compliance with or non-compliance with the conditions of his probation.
Your Honor, I am going to object because there was prior testimony, it is hearsay, that she was not his probation officer. She was a supervisor of a supervisor. So it's based on hearsay.
I can lay a little bit of a predicate if you'd like, Judge.
Sure, go ahead.
You were not the actual probation officer that supervised this defendant, correct?
Correct.
But nevertheless, is it part of the duties of each individual probation officer to make entries, or what some of us old school lawyers and old school probation officers refer to as chronos, right?
Yes,
It's essentially like notes that are put into the system or the database
yes,
about the defendant or about certain events or activities in their case, right?
yes,
And have you reviewed the chronos as it relates to this particular defendant in this community supervision?
yes,
Okay.
Okay. I'm sorry, again, yeah, it's like a police report. Another officer cannot testify as to the information of the report. She testified earlier that she had no knowledge of Asa Jones and that was not her supervisor.
So these are business records maintained in the ordinary course of probation department's business. Right?
I don't remember what exhibit that was, Judge. And again, I object even to the business records of her testifying as to somebody else's information.
Sustained.
One of the questions I'd like to ask is about whether or not his probation is extended. That's not hearsay. That's represented by a document, an actual document, Judge.
I'll allow that.
In this particular instance, was this defendant's probation extended?
not in the case I talked about yesterday.
Was his probation or a previous probation ever extended?
Yes,
Typically under what circumstances? So he's had two probations, right?
correct.
Okay. Typically under what circumstances would a defendant's probation be extended?
Typically, it's to allow them additional time to be compliant with the terms of their probation. Mostly includes their court order fees, give them additional time to pay court order fees and or community service or anything else particularly that hadn't been completed.
The records as it relates to the extension in that probation, what do those records indicate? Not what somebody entered into a system or notes that somebody put into a system. What does the actual document indicate was the reason for the extension? If you know.
Again, objection, Judge, same thing.
Sustained. If someone else entered it into the record, then it's hearsay.
Is it with regard to the probation the defendant was on during the commission of the offense, the aggravated assault that we're here on? Was it a prohibition? Was it prohibited by his conditions of probation to not commit any other offense or violate any other laws of the state of Texas?
Yes,
And you are aware this jury has found this defendant guilty of aggravated assault, correct?
yes,
And that is a violation of the Texas law, correct?
correct,
And in turn, as such, it's a violation of his probation, correct?
correct.
That's what the judge.
Thank you. Any questions, Mr. Burbank?
I do.
Okay.
How long have you been a probation officer, ma'am?
Since 1998.
You have supervised, or have you known individuals that have been on supervision for aggravated assault?
Yes,
As a person that is under probation, they're under a number of rules, correct?
correct,
And it's under the supervision of the court. But you supervise a probationer for the court, is that?
Yes.
Did I say that right?
correct,
Court puts them on probation and then says you supervise them.
correct.
In that supervision, there are a number of regulations or rules that someone needs to abide by.
Yes,
Agree with me?
yes,
Couple pages long.
yes, yes,
There's curfew,
yes,
There's no drinking of alcohol or drugs.
Correct.
Staying away from certain people of bad reputations or things like that, right?
Yes,
There's community service.
yes,
And felony community service usually is much more than misdemeanor, isn't it?
yeah, yes,
I mean, you're looking at several hundred hours of community service over the term. And misdemeanor is usually about 40 or 60, correct?
yes,
Sometimes.
yes,
Okay.
yes,
Um, now, the term of supervision, is it your understanding through your experience is that the jury in this case has found him guilty? And they have to assess if he's qualified for probation, to assess whether or not one either gonna sentence him to penitentiary time, for TDC time, or or say, I recommend probation, right?
yes,
From you. And one of the requirements though is that if they do decide to put him on probation, they cannot assess a term of more than 10 years incarceration.
correct.
Now, I want to talk about that a little bit through your experience. The term that they put on, and in this case, it's a first degree felony, it's no less than 5 and no more than 10 years incarceration, right?
For probation,
For, yeah, for
Purposes,
probation.
yes.
If they assess that, then they can go ahead and recommend to the court the assessment of probation, correct?
yes,
Probation can be anywhere from, in this case, 5 years up to 10 years, correct?
correct.
But that is set by the court in reference to the length of time. Agree with me? They have to recommend it, but
Yes,
the court assesses the
Yes.
length of time of probation.
yes,
Probation can be anywhere from 5 years to 10 years, right?
right,
And then subject to that, if he violates it within that period of time, then he's subject to whatever prison term they assess. For instance, if they assess 10 years and he violates any rules of probation, then he is looking up to 10 years in the penitentiary.
yes,
Okay, just as if it's all 5 years, and he violates it, he's only looking at up to 5 years, well, which is the minimum, but which is a bad example. But he's looking at up for 5 years, correct?
correct.
Okay. So it's important that if he is considered for probation, that the term of prison can't be assessed more than 10 years by a jury.
Correct.
Okay. Also, with the rules of probation, there are also programs, correct?
Correct.
That the court can assess or probation can assess, right?
Correct.
They can send them to an ISF program. What is ISF?
It's an intermediate sanction facility. We have two types. One is the cognitive track, which helps with their criminal thinking errors. And then we have another track that addresses substance abuse.
Substance abuse. So if he had a problem with drugs, for instance, if this case was a controlled substance and he had prior controlled substances, that may be a program to say, hey, you might have to do that.
Correct.
There's also safety in that too,
Yes.
which is a lockdown facility and a state jail facility.
Yes.
Correct? Okay. And that's usually done by an assessment by the probation department to see whether or not a person needs help.
Correct.
And then you said one of them was cognitive,
Yes.
and that's basically is you're going down the wrong path. You need to get straightened out.
Correct.
And that's a program. Is it like a self-help program or was it a lockdown facility?
No, it's locked down for
Lockdown?
yes, for 90 days.
And it could be whatever time, depends on how a person acts.
Correct.
If they abide by everything, it could be shortened or long, whatever it might be, correct?
I don't know about the shortened, but it can be extended.
It can be extended.
Yes.
And the purpose of that is saying you're getting your second chance or you're getting, you're not going to the penitentiary.
Correct.
Okay? So we're trying to help you make the right choices.
Yes.
I had also heard that and I was wondering that probation also tries to help with employment.
Correct.
In fact, did you ever hear of people that if they wanted to become a truck driver, they send them to LIT through some programs
Yes,
or processing or anything like that, trying to help them along, right?
correct.
And do you see that in your experience, that sometimes employers don't want to take a chance with somebody on probation?
Yes,
And so you try to help them get over that hurdle and try to pick an employer that will give them a second chance.
yes,
Through your experience, Ms. Roach, does a lot of the problems that probationers have is money, trying to get a job, maintain jobs,
yes,
to try to get, I guess, back on their feet again and try to be productive.
yes,
And have you seen that if that doesn't happen, they start running into problems, don't they?
yes,
They have families and things like that.
yes,
So there's a whole bunch of regulations and rules that if somebody is granted probation, that they would have to abide by over whatever period of time, in this case, no less than 5 or 10 years.
correct.
Okay. If they violate, then does it usually come through the probation department? The violation?
Yes,
I mean, if they get arrested again for another offense, you get the police report, or you get notified by the jail, he's back in custody again.
yes,
If he's not complying with community service or not going to the counseling or programs or whatever it might be, that's generated through your office.
yes,
And then somewhere down the line, there's an administrative hearing,
yes,
and then that recommendation is then sent to the judge.
correct.
And when you send it to the judge, is that to determine whether or not they need to file a motion to revoke this
Yes.
person's probation?
Yes,
And then the judge says yes or no.
correct.
The judge then puts him back usually in custody, either holds him in custody or lets him set a bond, but there's a hearing in front of this court.
Yes, yes,
So if somebody is given probation, stands here and is given a second chance, and then he has to come back in front of this judge if he doesn't take advantage of that second chance.
yes,
And this judge would have to decide what to do with the person.
yes.
Have you, in your experience, have you had probationers that have used deadly weapons on probation?
Yes,
Have you had probationers that have been given second chances, like 2 probations or so?
Yes.
Does it make a difference in reference to a probationer's age?
no,
And they would have to report how often?
it depends on what level of probation they would be on.
That's what I wanted to get to. There are different levels of probation.
Yes,
And what are the levels?
you have the low risk, a moderate risk, or a high risk.
Okay. And don't you have like a 0 tolerance too?
Yes,
Which is that what you call the high risk?
yes,
Okay. Low risk is, we think everyone's gonna be compliant, the probationer is gonna be compliant. And he may report or she may report once a month.
Correct.
or As long and comply with either writing in or calling or doing whatever, and you think they're going to complete it.
yes,
If you think that a probationer is going to maybe a little bit of attention getter or you need to keep track of them. So then it kind of goes to medium high.
yes.
Tell me a little bit about 0 tolerance through your experience in reference to probation.
Zero tolerance is usually, the judge usually sets that and, mostly because they've been in front of her on some allegations. And, his probation may be reinstated, and zero tolerance means don't mess up. You do anything wrong, you're coming back to court, possibly facing going to prison.
I mean, it's like if you test dirty, it's a violation. I'm ordering you bring him back to court.
Yes,
If he doesn't show up, if he doesn't comply with community service or anything within your multitude of rules, it's zero tolerance. You didn't do it. Back in front you go.
yes.
And through your experience, have there been many people on zero tolerance?
Yes.
Pass witness.
No further questions for Ms. Roach, Judge?
Thank you. Any objection to Ms. Roach being excused?
No, no.
Thank you, ma'am.
Thanks.
Mr. Coleman?
State calls Hunter Freeman or recalls Hunter Freeman.
And Mr. Freeman, you're still under oath from before.
Yes, ma'am.
Have a seat. Go ahead.
Thank you, Hunter. Thank you, Hunter, for coming back. Just for the record, state your full name, please.
Hunter Allen Carl Freeman.
You didn't want to be here this morning, did you?
No, sir.
In fact, you told me you didn't want to be here.
No, sir.
Why not?
It's a little hard to talk about sometimes.
What makes it hard?
Just everything, bringing it back up. Just after a whole year, you tend to kind of put it past you just a tad bit, or try to at least.
Have you been successful in putting it behind you?
No, sir, not really.
In what ways does this, what happened to you, affect you and your life?
It's hard to sleep sometimes. Constantly remember the gunshots and everything. You're hearing in my ears at least 3 or 4 times a day. I can't hear out of my left ear damn near at all. I still do have clear hearing, but it's muffled. You can just tell the difference between your left and right side. My teeth, they tell me I can never have a full set of teeth again, most likely, not unless they do some sort of more surgeries, and it's just it's still hard to eat sometimes. Can't eat certain things, whatever, just because of how sensitive everything is.
And you understand this jury's tasked with assessing what they consider to be the appropriate punishment for this defendant for what he did to you. You understand that?
Yes, sir.
You understand they've got a really wide range to choose from, anywhere from letting this defendant walk out of this courtroom with a piece of paper and promises what they call probation, all the way up to 99 years of life in prison. You understand that's on the menu for this jury, correct?
Yes, sir.
Have you given some thought as to what you think justice would be and what you would ask this jury to assess in the way of punishment?
Yes, sir.
And what would that be?
Be 40 years, sir.
You don't reach that, or you didn't reach that conclusion lightly, did you?
No, sir, not really.
You gave it some thought.
Yes, sir.
Why do you say 40 years?
I don't want him to go to life forever. I don't want him to be in prison forever. Everyone makes mistakes, sir. I do understand that. But also what he did was wrong. And I just don't think he should be able to walk away from it either.
I mean, you've got to live with those memories for the rest of your life, right?
Yes, sir.
You've got to live with your hearing loss for the rest of your life, right?
Yes, sir.
And you've got to live with the issues with the loss of your teeth and not being able to enjoy food and a meal as a result of losing your teeth. You've got to live with those consequences for the rest of your life, correct?
Yes, sir.
That's the way it's.
Thank you. Any questions?
John. Again, good morning, Mr. Freeman.
Good morning.
40 years. Let me ask some questions.
Go ahead, sir.
Mr. Freeman, if you were sitting there and Asa was sitting there and Asa was asked, what do you think the appropriate punishment might be? Okay. And Asa said 40 years. Okay, 40 years. How old are you?
23.
63 years old. And this is based on testimony yesterday from you that said, I caused it, right? You testified to that. So you have to answer.
Yes, sir.
I taunted him. Remember
Yes, sir.
saying that? I said, come on, do it.
He couldn't have heard that statement, though, but yes, sir.
But you said that,
Yes, sir.
okay? And you said, I wasn't going to back down because that's how I wasn't taught.
But I did back down, sir.
No, but did you testify to that?
Yes, sir.
Okay. And so with that being said, and that belief, 40 years,
Yes, sir.
some another individual that did that and said that, which was you, and he reacted to it.
Yes, sir.
Nothing further.
Mr. Coleman?
Hunter, are you on trial here today?
Yes, sir.
Sir,
Yes, sir.
Asa Jones is on trial for shooting you in the face, right?
Yes, sir.
Could you in any way on God's green earth have envisioned that when, regardless of how that road rage began or started, or who cut who off first, is there any way you could have envisioned that this defendant would pull out a gun and shoot you in the face?
No, sir, because I have one on me myself and I did not even think of even reaching for it.
Thank you. I'll pass.
Two last questions. This started approximately 2 to 3 miles before an actual shooting. That's what the testimony indicates, right?
Yes, sir.
So for 2 or 3 miles, you had a chance not to cause it, not to taunt him.
So did he, sir.
Okay. Not to taunt him. And not to just stay there because no one was gonna do that to you. Right?
Yes, sir.
I have nothing for them, Judge.
Thank you. You can step down. Any other witnesses?
Texas race judge.
Thank you. Mr. Burbank?
I call Ace's mom.
What's the name?
I told you I can't because I forgot.
Okay.
He's outside, Judge. It's
Good morning, ma'am. Good morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can have a seat. And if you'll just do your best, kind of pull that microphone over, make sure you speak loudly and clearly so everyone can hear you. Also, if it's a yes or a no question, be sure to say yes or no, not just a head nod or an uh-huh, so the court reporter can take everything down.
Yes.
Thank you. You may proceed.
Please, for the record, state your name, please.
Karen Denise Spencer. Karen Denise Spencer.
Spencer?
Mhm.
I apologize for not knowing or remembering your name,
It's okay.
but I drew a blank. Ms. Spencer, are you Ace's mom?
Yes,
You know that this jury now has convicted your son of aggravated assault in
yes, sir.
reference to the incident that happened on East Texas. They now have to try to determine what punishment might be appropriate. You
Yes, sir.
understand that? Now's our time to kind of talk about Asa. Okay, how many other children do you have?
4,
Okay, and how old are they?
31, 30, Asa 27, 25, and 22.
And did they all live together at one time?
They all grew up together. I was a single mother.
And fathers, was Asa's dad around?
No, sir.
Okay, where was Asa's dad? Do
No
you know?
clue. No clue.
No clue, never had anything to do with him.
No, sir.
Did he ever have a father figure in his life that he could rely upon like a dad?
Well, I have several brothers.
Okay. Some of your brothers, did they go to the penitentiary?
Yes,
So maybe not very good role models.
correct.
Okay. What part of town did you grow up or did you reside in?
The North End.
North End.
Yes, sir.
And we had testimony from a police officer here that knew Asa in school. What elementary school and middle school did he go to?
French, Caldwood, French and Caldwood.
Okay. And then middle school, was that
Austin and Vincent.
okay? After he finished middle school, what high school did he go to?
Central.
Central. Somewhere in Central, did he graduate?
No, sir.
How far did he get in school?
The 10th grade.
Okay. He was still living with you.
Yes, sir.
When he dropped out of school, did he just sit around or did he get a job?
Oh, no, he always had a job.
Okay, and tell us what type of work that he did.
Well, from maybe 15 to about 23, maybe, he worked at a convenience store. It was a family-owned convenience store.
Okay,
And then he worked at Popeyes. He worked at Focus, which was like a call center or something.
is that the one on Lucas?
Yes, sir.
That the old Lucas and
Concord, yes, sir.
okay. I worked there. Okay, so he always had some type of trying to make a living.
Yes, sir.
With his money, did he help out with the
Oh,
house?
very free-hearted. We wouldn't have on bills. Or if I told him that a bill needed to be paid, he paid it because I was a worker as well.
Did he get along with his siblings?
Oh, very close.
He hasn't been perfect. He had some run-ins with the law with misdemeanors, some guns and this and that. Did Asa ever have an incident where he had been shot?
Yes,
Okay. And when he got shot, was it at his house?
yes.
And was he doing anything wrong or was he just shot?
Well, not to my knowledge, he wasn't doing anything wrong,
Okay,
but the house, I don't know if it was, I'm not really sure what happened in the situation, but the house did get shot up and he was hit with, I think, 2 bullets.
okay. It's kind of like standing around.
Yeah. Well, no, actually, he was in the bed. It happened at 4 a.m. in the morning.
So he was in his own bed.
Yes.
And did that affect him?
I'm sure.
Do you think he got hit with 2 bullets?
Mm-hmm.
How long ago was that?
2020, I wanna say.
2020.
Yes, sir.
Okay. Does he have any kids?
2.
Two?
Mhm.
And where do they reside? What's
With their
it,
mom,
huh?
with their mom.
In Beaumont?
Mhm.
And as,
Okay.
as grandma, what type of interaction do you see between your son and his children?
Oh, we have a very pretty good relationship with the grandbabies.
So is he actively involved?
Yes, sir. And so is me and my daughter.
Going to any of them at school?
Yes, sir.
Does he go to school, for functions?
Yes, sir.
How about extracurricular activities?
Every once in a while, every
Okay.
once in a while.
Does he provide for his kids?
Yes, sir. And whatever he can do, me and my daughter does.
Okay. Unlike his dad. You think he possibly learned that he didn't want to be like his father?
Yes, sir.
So he's been active with his daughters.
Yes, sir.
We had heard testimony that he waited till after Father's Day to turn himself in because he wanted to spend time with his daughter because he knew possibly he was going to get arrested.
Yes.
Did you know that?
Yes, sir.
And did he actually spend time with his daughter?
Yes, sir.
Has Asa had your support since this incident?
Yes, sir.
And
He's
his family, I saw his aunt sitting back here. Is that your sister?
Yes, sir.
Do y'all have family support?
Yes, sir.
Okay. Ma'am, if you were sitting there now and there was a person sitting here that was involved in an incident similar to what we had here today, that is driving along East Tex Freeway, leapfrogging a road rage, but ultimately ended up with somebody sitting here shooting into a car at least 6 times and striking one of your children. Thank God not dead. And you were sitting there and you were asked, what should be done to that individual? What should be done to that individual that did that to your child? Tough question, isn't it?
It is.
Can you see both sides?
I can't.
What's your thoughts?
I know Asa made a bad choice. I do. But to hear the victim say what he did, and I'm not saying what my kid had done was right, but I feel like both parties should be,
Some type of responsible.
yes.
You may not agree with their decision, but this is what we asked them to do, right?
Mhm.
And you respect
Yes,
it,
sir.
right?
Yes, sir.
Okay. So what type of punishment do you think he should get?
I mean, I seen the guy ask for 40 years. I don't think that Asa should get 40 years. The victim. I don't think Asa should get 40 years. I do think that he should get punished, but I do not think 40 years.
Are you asking this jury to consider what I call the totality of the circumstances? That is, everything that's involved in this case.
Yes, sir.
And come up with a punishment that they feel is just.
Yes, sir.
You would agree that there were 2 parties involved in this, correct?
Yes, sir.
It wasn't just like someone walking up to a convenience store and robbing or meant to go out and do something.
Yes, sir.
I say robbing or theft, right?
Yes, sir.
And you asked the jury to take that into consideration,
Yes, sir.
that it was 2 parties and a bad choice.
Yes, sir.
Pass the witness budget.
Thank you, Mr. Coleman.
Good morning, Ms. Spencer.
Good morning.
I'm so sorry that you have to be here. I'm so sorry that we have to meet under these circumstances. I just have a couple, two, maybe three questions for you, please. You understand and you testified that Asa grew up without a father figure, but you understand that many people grow up without father figures and they don't end up shooting other individuals in the face. Is that fair to say?
Oh, yes, sir. I grew up without a father.
Okay. And I want to piggyback on what Mr. Burbank was asking you with regard to the appropriate punishment in this case. And it's just quite simple. I just want to ask you, if someone shot Asa in the face, would you want them to walk out of the courtroom on probation?
I mean, honestly, I wouldn't wish 40 years on anybody, even.
I understand, Ms. Spencer, but my question is a very pointed question. Would you want the person that shot your son Asa in the face to get probation?
Maybe.
You can envision a situation where if they shot him in the face, that you would be okay with them getting probation, yes or no, Ms. Spencer?
Yes.
Okay. Nothing further, Judge.
Thank you. Anything else?
No, yeah.
Thank you, ma'am. You can step down.
Thank you.
Asa Jones.
All right, Mr. Jones, come back up. And Mr. Jones, you're still under oath as well. You can have a seat. You may proceed.
Asa,
Yes,
I
sir.
know that you were down, right?
Yes, sir.
And upset in the sense of you've been convicted now, right?
Yes, sir.
You told your side, right?
Yes, sir.
And you still believe in what you said and what happened?
Yes, sir.
We talked a little bit, and did we talk about that we may not agree with the jury in the decision,
Yes, sir.
but just as I told you, do you agree that you respect their decision because that's what we asked them to do?
Yes, sir.
Okay. And that's like life, isn't it?
Yes, sir.
Sometimes people will agree, it's easy, and sometimes it gets difficult, doesn't it?
Yes, sir.
Right now, you're in a difficult part, aren't you?
Yes, sir.
They're going to decide what to do with you. We heard testimony from your mom that how old were you when you were shot while you were sleeping in your bed?
I think like 20.
20? So you didn't even know what was going on.
No, sir.
And when you shot once or twice,
Twice.
did it cause fear?
Yes, sir.
Were those people ever arrested?
No, sir.
Did you wish they were arrested?
Yes.
Okay. During this period of time, your mom said you were employed.
Yes, sir.
And what she said in reference to what you were talking about, what she was talking about in places that you worked, is that true?
Yes, sir.
And that you always work?
Yes, sir.
And you worked starting at 15,
Yes, sir.
and you helped your family out?
Yes, sir.
Okay. When you were working, why were you working?
Why was I working?
Yeah, why were you working?
Help my mom, really. Yeah, I really didn't much care about having money. I just really wanted to help my mom.
Well, you're 27?
Yes, sir.
Do you ever dream?
Dream?
Yeah, dream.
Yes, sir.
You ever dream of what you might want to be when you're,
Yes, sir.
I mean, you're getting old, not as old as me, but you're getting old.
Yes.
What do you want to be? What did you want to be?
But I wanted to be.
Yeah,
Growing up, basketball coach, something like that. They don't.
you like sports?
Yes, sir.
Want to be a basketball coach? Right? How about working?
Working.
I guess basketball coach is working.
Yeah,
but
but as far as working, it really didn't matter what I did. You know, I just like to work just so I can help my mom.
no matter what it was,
Help family.
basically.
Tell me about your two kids. How old are they?
6 and 7,
And the 7-year-old's name?
Chloe,
All right. And the 6-year-old's name?
Lakin.
When you had kids, I guess you were kind of young, 20 years old, 21 years old.
Yes, sir.
How did that make you feel?
I just wanted to be a part of their life because I never had a dad. So, you know,
How did you take it when you heard that you were going to be a dad?
I was excited.
You were young.
Yeah. Yes, sir.
You didn't finish high school.
No, sir.
You know, one of the things, if the court was to consider that steer was considered probation, you're gonna have to finish high school. I can tell you that's probably gonna be a requirement.
Yes, sir. I was in the process of getting my GED though.
You were.
Yeah.
How
Yes, sir.
far are you away from
Well, I was in the process
it? Okay.
of part.
Was this before you were put in jail?
Yes, sir.
So when do you think that would have happened? Would you have gotten it?
Yes, sir. Most definitely.
Okay. And why did you think that a high school diploma was a good thing?
High school diploma.
Yeah, graduating from
That's
high
it.
school, a GED. Why is that a good thing?
That's just something important that you like a achievement that you should want to achieve in your life.
You want to be somebody.
Yes, sir.
Um, you think it would open up doors
Yes, sir.
after you got high school? If you got a GED, would you have tried to go on to either college or some type of processing 2 year something to even better yourself more?
Yes, sir.
You have two girls. You've been in some minor stuff, misdemeanors, marijuana and guns and stuff like that. What kind of example do you think you are to them sitting here, sitting in county jail, not being a part of their life?
That's a bad example. It's like I made a promise to my daughter that I'd never leave her side, you know, and I broke that bond by making a huge mistake in my life, you know.
During questioning yesterday in reference to when Mr. Coleman was asking you questions. One is that, are you sorry for what happened?
Yes, sir, 100%.
You still believe in what happened and what you testified.
Yes, sir.
You're not changing the story.
No, sir.
Are you sorry of the outcome?
Yes, I am.
But you really didn't know what the outcome was going to be at the time you did it, did you?
No, sir.
But you know it's kind of stupid afterthought.
Yes, sir.
Did you ever intend to hit Mr. Freeman?
Not at all.
But you realize when you fire a gun,
It's a possibility.
so I guess the question would be, and I would anticipate possibly, a question of once I sit down is, one of your daughters was traveling down East Texas Freeway. Somebody came alongside them, road rage or not, back and forth, wanting to cause it or taunt them. And they shot. Went through one side and out the other. Now we're sitting here in front of the jury in reference to punishment. The person who did it, sitting here. What punishment do you give that person?
I mean, honestly, in my honest opinion, I feel like some people just deserve a second chance. You know, people make mistakes in their life. You know, some people just need a second chance to better themselves. You know, um, see how to say this. No matter the circumstance, you know, some people just need a second chance to reflect on what they did to know, like, well, I don't want to go back down this road, and I know what the outcome would be if I do this, so I don't want to make that mistake again in my life.
You know, I know when I sit down, here's some of the questions I anticipate you're gonna ask. Or are gonna be asked. Starting back in 2026. 2016, excuse me. You were arrested for UCW, right?
Yes, sir.
Given a year's probation. Why didn't you learn your lesson then? I know it's just a misdemeanor, and now you're in the big times. This is a felony, a first degree. You're looking at up to life in the penitentiary. Why didn't you learn then?
I wouldn't necessarily I didn't learn. It's just with my house being shot up like that, I feared for my safety. I just wanted to protect myself and my younger sister and my mom. So I don't know who shot me and why my house was targeted. So I wouldn't necessarily say I didn't learn because I did learn from it, you know. And them charges, I don't. It's really not just. I just was in possession of a gun. I never committed a crime or anything like that. So, but I did learn from my mistakes. I learned from all my mistakes.
You know, carrying a gun is a crime.
Yeah, it is a
You got
crime.
convicted of it.
It is.
So back in August, you had a couple of them, which were the same time. Possession, I believe. UCWs. How come you didn't learn then? I know it was another misdemeanor. How come you didn't learn then?
I wouldn't necessarily say I didn't learn. I just was in fear. I was like, for my safety wise, just overall safety wise.
And when this happened back in June 12th, 25, you were on probation.
Yes, sir.
You were under the rules. You heard Miss Roach, she wasn't your probation officer. You were under the rules. Right?
Yes, sir.
Second chance. Let me ask you this, Asa, and it may seem simple. When you left downtown on the 12th and were heading back up north of Tram Road, was it your intention to get into road rage?
Not at all.
Was it an intention to pull out your gun and if you feared for your safety or not feared for your safety or whatever, to shoot?
That was my intentions.
It happened in the heat of what was going on.
Yes, sir.
Did you realize that if you were 5 minutes or a minute before or after, this probably you wouldn't be sitting here?
Say it all the time. I say 10 seconds.
If this jury was to consider probation, there's gonna be an awful lot of rules and regulations, okay?
Yes,
In
sir.
reference to this. Do you think you can do it?
Yes, sir.
You were on probation when this happened,
Yes, sir.
okay? But now, instead of getting your 30 days or 50 days if you violated it or 180 days, whatever it is, you'll be looking at up to 10 years in the penitentiary.
Yes, sir.
Who in your family went to the penitentiary?
Uncles, cousins.
What'd they go to the penitentiary for?
I'm not sure on the charges, but just know they
How long have they been in?
years.
Huh?
Years. At a
Years?
time.
You look up to them?
Yes, sir.
Well, how do you look
I
up
did.
to them when they're sitting in TDC?
Well, at a point of time, I did.
You want to have a cell with your uncles?
Have a cell with them?
Yeah, have a cell.
No, sir.
Be in the same unit.
No, sir.
You think that maybe you could correct this?
Yes, sir. I'm all about breaking on generational curses.
Generational curse.
Not a curse, but like a
How about-
recycle thing, like, you know,
How about breaking your bad decisions so that you don't take the white bus to Huntsville?
that as well.
You asking this court or this jury to consider probation?
Yes, I am.
And you realize that if you do violate it, you'd be here, and this judge has listened to this testimony.
Yes, sir.
And do you know what the outcome would be if you violated, if they determined to give you probation? Do you want to take odds of what the outcome would be?
Up to what the case holds.
Yeah, you want to take a bet now if they were to give you probation? Let me answer it for you. 10 years. Not even in consideration. You realize that?
Yes, sir.
What have you done in the last 10 years in your life? How many birthday parties have you gone to?
Quite a few.
Christmases,
Quite a few.
4th of July's. We just did 4th of July.
Many.
You realize that if you were in the penitentiary for 10 years, these are everyday things.
Yes, sir.
And to Mr. Freeman, are you sorry?
I am very regretful. I'm just glad he's alive and he's okay today. Sincere from my heart, I do apologize for what happened.
Pass witness.
Thank you, Mr. Coleman.
Thank you. Just got a few questions for you, Mr. Jones. Maybe we can just kind of get through this as quickly as possible. Are you saying to this jury that the fact that you grew up without a father, the fact that you've been shot before, those are the reasons why you shot Hunter Freeman back in June of 2025?
No, sir, that's not the reason why.
Okay, thank you. Are you saying that this jury should feel more sorry for you than they do for Hunter Freeman?
Not at all.
Okay. You don't have any issues with your hearing, do you?
No, sir.
You don't have any issues with your teeth, do you?
No, sir.
But you understand that Hunter Freeman would have those issues for the rest of his life, right?
Yes, sir.
All right. Now, you have been convicted, albeit of misdemeanors. I will concede they were misdemeanors of 3 separate unlawfully carrying of a weapon. Let's start with the first one in 2016, I believe it was. No, 22. You had 2 of those in 2022. The first one in 2022, what kind of weapon was it? What kind of gun was it?
A handgun.
Do you remember the brand? Was it a Glock or?
I don't remember the brand.
Okay. This handgun, where'd you get it from?
Off the streets.
Who did you get it from off the streets?
I don't recall.
Because you used that term yesterday. I mean, I'm a little baffled by this term off the streets. I mean, you're telling me like Dowling just pops up a gun, or Concord pops up a gun and gives it to you? Or are you saying that there's an individual in the neighborhood that provides you with the gun? Is that what you're saying?
It's an individual. I just don't recall who.
Okay. Let me ask you about that second UCW, that second possession of a firearm in 2022. What type of gun was that?
A handgun.
Do you remember the brand?
No, sir.
Did the streets give you that one too?
Yes, sir.
You don't recall who gave you that one?
Not at all.
All right, let's move on to the 2024 unlawful carrying of a weapon. You know the question I'm gonna ask. Where did it come from?
Streets, and I don't recall who I got it from.
That's unfortunate. That is very unfortunate that you don't recall any of that. Let's move on. You understand that you have, by the decisions that you've made, put yourself, and by virtue of those decisions, your daughters in this situation to where they might not be able to see you. You understand?
Yes, sir.
I mean, there is an element of personal responsibility, you would agree, right?
Yes, sir.
I mean, once you become an adult, we're all kind of accountable for our decisions that we make and the consequences. Wouldn't you agree?
Yes, sir.
Your attorney, Mr. Burbank, characterized your actions that day as, quote, and I wrote it down, kind of stupid. I think I would beg to differ with that. Shooting a vehicle no less than 6 times as it's moving down the highway. Let me ask you this. Did you know if there was a baby, a child, a kid in the backseat of that Suburban when you fired off 6 shots at it? Did you know if there were?
No, sir.
Could have been, could it?
Yes, sir.
You could have killed a kid as well, in addition to shooting Hunter Freeman, right?
Nah, that's me.
This is not how this works. Your attorney can ask you follow-up questions if he chooses to.
Yes,
But you
sir.
could have killed a kid that day, in addition to shooting Hunter Freeman, right?
Yes, sir.
Those bullets could have ricocheted off or went through that Suburban and hit oncoming traffic. Wouldn't you agree?
Yes, sir.
Hunter Freeman could have become incapacitated, lost consciousness, and veered into oncoming traffic or hit another vehicle. Wouldn't you agree? Yes or no? Wouldn't you agree?
Yes, sir.
Okay, again, Mr. Burbank can ask you all the follow-up questions he wants to ask you.
You know, I'm going to object to the sidebar remark.
Overruled, go ahead.
You asked for a second chance, your words. But you would agree with me that you've already had a second chance. In fact, you've had a third chance when you received that first probation and the second probation. Wouldn't you agree?
Man,
Yes or no? You've had at least two prior chances before coming in here asking this jury for probation. Yes or no?
yes, but not a violent.
Excuse me, non-responsive
Not a
judge.
crime.
You are not asked the instrument.
Just answer the question.
Can I say one
This,
thing?
no. This is how it works. Mr. Burbank can get up in just a minute and follow up on any of these questions with any explanations, okay? It'll just be easier if you answer it how it is. Mr. Burbank can stand back up and ask you questions, okay?
You understand those are the rules of court, right?
What's the rules?
What's
Just ask questions.
That's my question.
Yes.
You understand my
Now,
question?
ask a question that has to do with
Well,
this.
I'm gonna tie in, just give me one more
Okay.
question. I'll tie in.
Go
You
ahead.
understand those are the rules of this
Yes,
court,
sir.
right? And you understand that there were rules in the jail that you had to follow too, is right?
Yes, sir.
Did you follow the rules in jail?
I did.
By throwing urine on another inmate that you didn't break the rules?
It wasn't urine.
Yes or no? By throwing it, well, let me ask, okay, even if it wasn't, by throwing another substance on another inmate.
I got
was that-
gas first.
Listen. Mr. Jones,
It's not justifying my answer. I'm just saying. He asked me
Listen.
a question that comes with explanation. Like it's a
you're,
yes or no.
listen. Listen to the rules. Again, right now in court, listen to the rules. The rules are answer his question. If there's an explanation, your attorney can stand up, ask you for an explanation, and you can give that explanation. That's the third time I've told you,
Yes.
yesterday and now today twice.
Thank you. You didn't follow the rules regardless of what you threw on that other inmate, did you?
I follow the rules in jail.
And that's what you want this jury to believe.
I do.
Okay. You also said that you've learned and reflected on your mistakes. Is that what you want this jury to believe?
Yes, I do.
And this jury will make the determination as to whether or not you can follow the rules. Because probation, you would agree with me, has rules, right?
Yes, sir.
And you violated the rules of your most recent probation by committing aggravated assault, correct?
Yes, sir.
All right, that's the witness, Your Honor.
Thank you, Mr. Burbank.
Asa, when you were trying to explain in reference to the jail, did you have a conflict or beef or having problems with another?
Yes, sir.
And there are rules in jail, right, between inmates,
Yes, sir.
kind of like survival, right?
Yes, sir.
And prior to you throwing whatever you threw, did that person do the same thing to you?
Yes, sir.
And it just kind of boiled over, right?
Yes, sir.
But nothing really, you were sent back to the door.
Yes, sir.
Are you still asking? I know you want to say something. What do you think you want to say that's important to the?
Judge, I would object to the form of that question. That's just an open question about what you want to say.
Sustained, that's good.
Does it have to do with the jail?
The question that what you mean? That
I can't read your mind. I'm gonna tell you that right now. I pass the witness, Judge.
I have nothing further to this defendant, Judge.
Thank you, Mr. Jones. You can have a seat, please. Mr. Burbank,
We rest.
all right, any rebuttal?
No, Judge.
So ladies and gentlemen, what that means is that at this time you have heard all the evidence with regard to punishment. And so the same thing happens. We've got that court's charge. I did stay and prepare it yesterday. We need just a few minutes to go over that and then we'll have it ready. What I'd like to do, probably, it's a little bit early, but instead of, let's do this. Let's go ahead and take an early lunch. That way you can go ahead and get lunch. We'll make sure everything's ready. When you get back, we'll read the charge and the case will be submitted to you for deliberation. It's 11:20. I'd like to get started at 12:30. So it's a little over an hour and 10 minutes or so. Please keep in mind all those previous instructions that you were given. If everyone else would please remain seated in the courtroom, you're excused until 12:30. State's attorneys present, defendant and defense counsel are present. Everybody's been given a copy or emailed a copy of the court's proposed charge. Any other additions or corrections or objections to the charge?
I'm going to say, Judge.
No objections, Judge.
All right, then, how long would either of you want me to give you a heads up on time?
10 minutes, Judge. I'd like 10 minutes total, Judge.
Okay, you good with, I'll let you know if you start going too long. You could bring the jury in. Hey, Tommy and Tom.
Still many times.
On your last page. And I'll print that. All right, let the record reflect the jury is seated. State attorneys present, defendant and defense counsel are present. And ladies and gentlemen, at this time, just like before, I'm required to read the court's charge to you. Cause number 25 DCCR 0963, the state of Texas versus Asa Joseph Jones, jury instructions. Members of the jury, you have found the defendant, Asa Joseph Jones, guilty of the offense of aggravated assault. Now you must determine the punishment to be imposed on the defendant. The parties will soon present final arguments on punishment. Before they do so, I must now give you the instructions you must follow in determining the defendant's punishment. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will tell you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment phase. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that's in dispute. You must arrive at the amount of punishment by a fair, full, and free expression of the opinion of the individual jurors. You must not decide the punishment by lot or by chance. For example, you may not agree beforehand to be bound by the result of a procedure by which each juror gives the number of years the juror thinks should be served. These are then added, and the result is divided by 12. To reach a verdict, all 12 of you must agree. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you'll go into the jury room. The foreperson should conduct the deliberations in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must stop your discussions about the case until all of you are present again. 3, you must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. And 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Sorry. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. The defendant has asked that you recommend he be granted community supervision. You may, in this case, be able to recommend that the confinement assessed by you, any fine assessed by you, or both be suspended and the defendant placed on community supervision. Community supervision is often called probation. The 2 terms mean the same thing. If the defendant is placed on community supervision, the defendant will not be required during the period of community supervision to serve the period of confinement assessed by you. If you assess a fine and recommend that the fine be suspended, the defendant will not be required during the period of community supervision to pay that fine. If the defendant successfully completes the period of community supervision, the court will discharge the defendant. A defendant so discharged will never have to serve the confinement assessed by you or pay any fine that you have recommended be suspended. During the period of community supervision, conditions will be imposed on the defendant, and the defendant will be placed under a variety of programs. If the defendant is believed to have violated the conditions of community supervision, the defendant will be brought before the court. The court, after a hearing without a jury, will either continue or revoke the community supervision. If the court revokes the community supervision, the court will dispose of the case as if there had been no community supervision. It will sentence the defendant to a term of confinement not exceeding the term assessed by this jury. It may also require the defendant to pay any fine assessed by this jury that the jury recommended be suspended. The duration of the period of community supervision will be determined by the court. It may not be for a period of longer than 10 years. If you recommend that the defendant be placed on community supervision, the court must grant the defendant community supervision. In addition, if the defendant is granted community supervision, the court may impose any other reasonable condition that is designed to protect or restore the community, protect or restore the victim, or punish, rehabilitate, or restore the defendant. During the period of community supervision, the court may at any time alter or modify the conditions imposed on the defendant. If the defendant is placed on community supervision, the court will determine what conditions to impose on the defendant. You may recommend that the defendant be placed on community supervision only if both of two requirements are met. One, the punishment you have assessed is not more than 10 years confinement. And two, you find the defendant has never been convicted of a felony in this or any other state. If you decide to recommend that the defendant be placed on community supervision, you should indicate whether you recommend suspension of the term of confinement, any fine, or both. If you decide not to recommend that the court suspend the sentence and place the defendant on community supervision, you should use the verdict form that does not recommend community supervision. Specific law applicable to this case. You have found the defendant, Asa Joseph Jones, guilty of aggravated assault. This offense is punishable by 1, a term of imprisonment for no less than 5 years and no more than 99 years or for life, or 2, a term of imprisonment for no less than 5 years and no more than 99 years or for life and a fine of no more than $10,000. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed or 30 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if he's sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. And then that has my signature on it. And then you have actually 2 verdict sheets, and you'll obviously only pick one of those. The first one is titled Verdict, No Recommendation of Community Supervision. And it reads, we, the jury, having found the defendant, Asa Joseph Jones, guilty of the offense of aggravated assault, assess his punishment at, and then you have 4 choices and you would only select one. The first, imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 99 years and no fine. The second, imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 99 years and a fine of blank, $10,000 or less. The third option, imprisonment in the Texas Department of Criminal Justice for life and no fine. And then the last is imprisonment in the Texas Department of Criminal Justice for life and a fine of blank, $10,000 or less. And again, that has a space for the signature and the printed name of the foreperson. And then the second verdict form is titled Verdict, Recommendation of Community Supervision. We, the jury, having found the defendant, Asa Joseph Jones, guilty of the offense of aggravated assault, assess his punishment at. And then you have 2 choices on this one. The first is imprisonment in the Texas Department of Criminal Justice for a term of blank, and it would have to be between 5 and 10 years and no fine. The second is imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 10 years, and a fine of blank, $10,000 or less. And then it further reads, having assessed punishment at no more than 10 years imprisonment, we further find that the defendant has never been convicted of a felony and recommend he be placed on community supervision. We recommend suspension of, and then you'll pick out of the 3 following. The first, the term of imprisonment only. The second, any fine assessed only. And the third is the term of imprisonment and any fine assessed. And then again, that has the signature name, for the signature line for the name of the foreperson. All right, Mr. Coleman, the state has the right to open and close closing arguments.
State waives its right to open, but reserves its right to close, Your Honor.
Thank you, sir. Mr. Burbank, you may proceed.
Please court, counsel, as always. Sometimes as a defense attorney, it's kind of hard when you stand up in front of a jury after the guilt innocence and you return a verdict of guilty. Because you kind of put up your defense and what you think is relevant to the case. And sometimes people think, well, if they're guilty, they just don't believe you. I have a little bit of a different outlook in that, as I said, in Monday, we could not come up to a decision. I told you I believed in the system, and I do. I may not agree with your decision, but I respect it because I respect the system. And this is what we asked you to do. Now, though, we have to decide what is proper punishment. And I know there is not a person on this jury that has a blind eye or is oblivious to what's going on in society today. You hear it every day. I'm busy, sad to say, for representation of what's going on. And when you put together the violence and things that are happening, it makes people mad. And it should. But as I sat here this week, as I sat here at night, because when I get into trial, my focus is you, ladies and gentlemen, that present the presentation of my case and my client that I've known. And I look at things. And I look at things over the 36 years that I've been practicing in reference to different cases. And I want to submit some things for your consideration, and it's not evidence. I don't condone crime. I represent people that have been accused of crime. And I represent that I very seriously take it that I represent my client to make sure the state proves their case and presents the best I can to the jury. In this case, there's some differences here. I think the end result, very lucky for both sides, that went out in a murder trial and another person has been killed. But there's differences. And the difference is that this crime, as you looked at the jury instruction yesterday, did not have the definition of intentional. It had knowingly and recklessly. And I would submit to you it was probably recklessly. And that's a difference in the legal world. And you're probably wondering where I'm going. Asa was on probation. Yeah, you know that. It's a given, misdemeanor. Never been convicted of a felony. Okay, so he is eligible for probation. Asa was going to a friend's house to go fishing. There's nothing to convert that. Anything that says he wasn't doing. Controversial, excuse me. When you look at crimes and offenses that have happened in this society, this is not a crime in where he says, I got mad at you, I don't like you anymore, I'm going to kill you. So he goes to the house or he goes somewhere and shoots and kills somebody. This isn't a crime that says that I'm going to sexually assault somebody and I groom you and it comes over a period of time and it happens. Or it's an aggravated robbery in which you intentionally want to go into a store to rob, you have a gun, and as a result of your actions, you pull the trigger and you kill the clerk. That's intentional. But there's no evidence that was presented that at June 12th, okay, in 2025, that as he set out, and you know that he was downtown at one time, about 3:30, 3:45 in the afternoon, that he intended to be in a road rage on East Tex Freeway. Wasn't. Now, you heard his testimony yesterday. And that he felt threatened. Okay, now I understand you didn't think that it rose to the standard. I understand. But in his mind, he felt threatened. If he didn't, he probably would never have pulled a gun and did what he did, which is foolish. I'm telling you, don't solve problems. But in that moment, he thought that was the solution, right or wrong. He didn't go out to do this. He didn't go out to say, I'm going to rob you or I'm going to murder you. It could have ended that way, but not. And I think that's where the difference is. The other difference is, and I'm glad that Mr. Hunter Freeman is not dead from where it was. But it bothers me, and it's just me, that somebody would say, I caused this. I taunted him. I said, come on, do it. Basically, if you're going to do it once he showed the gun, if you take it that he brandished it or he waved it at him, come on, shoot me. And I wasn't going to back down because that's how I was raised. That bothers me. And I ask you to consider that in the deliberation. And that both of them should have parted ways and gone their own ways. Both of them, especially, and Mr. Freeman's included, that if you take it that he's doing 70 miles an hour at 4 o'clock in the afternoon on East Tex Freeway, and we saw how busy it was, doing what they were doing, would have had some type of sense saying, I'm not going to taunt him. I got to get away from this. Just as Miss Jennings said, what are they doing? They're going to kill somebody. But emotions, the time, the instance, neither one of them were thinking rationally. And I don't say this lightly. I don't. Because this isn't the way society is supposed to be. But I ask you to take that into consideration because I believe, and it's just my opinion and it's not evidence, it's just my opinion for your consideration, that it is a little bit different than other offenses and crimes that we usually see. People going to apartments, going after somebody, going by drive-by shootings because there's an intention of getting in the car and going and shooting up somebody or someplace. Or going up to somebody and shooting them because you don't like them at a fight or something like that, you know. But I submit to you that in this case, it was the heat of the moment and it should never have happened. Asa is eligible for probation. I know he was on misdemeanor probation, but it's a little bit different if you're on felony probation. It's a little bit different environment on felony probation if you screw up. You know that there is rules and regulations in reference to what he's going to have to abide by, and I ask for your consideration in that. One of the things, though, is it would have to be, or it can be up to a 10-year period if you assess a 10-year prison term. So that's supervision for up to 10 years on this. If not, as the court has said, there is no jury, there's a hearing. And she determines, she being the judge, determines the violation and whether or not to be punished. I ask you to consider that. If it is not probation, I ask you to consider it when you decide the term of years. I don't believe it's worth 40 years. But that's up to your decision. One of the things I do want to point out to you is this. As page 4, and that is, he's never been convicted of a felony and no more than 10 years assessed. The court will assess the time. I will tell you that it will be 10 years. On probation. One of the things is here is the fine. The fine does not go to the complainant or the victim. So when you look at that, it goes to about 32 organizations. One time when we were waiting for a jury, a court, a judge and I, and some other prosecutors. It was like 32 state organizations that get a little bit of whatever the fine is. So I want to let you know that, because a lot of times jurors will say, does it go to a victim or something, restitution, and it does not. I will submit to you, though, that if you consider probation and with a little more hammer, you can assess a fine of $10,000. I would recommend and hope, if you did consider that, that you wouldn't make it payable at this time, but that you would put it over his head, saying, okay, you can still be assessed it if you screw up. I know that you deliberated in there. I know that you looked at everything, since I wasn't spying on you, but that you took your time and you did what I asked you to do and what Ace asked you. I asked you to do the same thing and take everything into consideration. There's no doubt that society today, the youth, we have a problem. But in the same token, I'm going to submit to you that this offense, this case is kind of unique and different. And that somebody didn't set out to do this. Somebody didn't say this morning, this is what I'm going to do. It is a terrible mistake. He has to pay for what he did. Thank God no one was killed. And I ask you to take consideration of that. And thank you for your time.
Mr. Burnett. Mr. Coleman.
Thank you, Your Honor. May it please the court. Mr. Burbank, ladies and gentlemen of the jury. I want to begin like I began during the guilty innocence phase, where I gave my closing remarks by thanking you all for your time, thanking you for your attention. And I want to say that when I first heard about this offense, I heard about it on the news. I vividly remember it back in June, on June 12th of 2025, watching it on the news, and it offended me deeply. It very deeply offended me that someone, over something so stupid and trivial as being cut off, would shoot somebody in the face. And when this case landed on my desk and I started to review the case and the reports, I remained offended that not only that this was a criminal offense, it offended the penal code, but it offended my sense of human decency. It offended my sensibilities as a member of this community, because it shouldn't be this way. It should not be this way. Mr. Burbank would draw a distinction and everything. This is not the typical gun violence crime that we're seeing in Jefferson County. I submit to you that it is. This is typical of someone who just has a dispute with somebody and instantly goes to the gun, resorts to the gun to settle that dispute. It doesn't have to be this way. It shouldn't be this way. and you can send a message via your verdict to say, we will not tolerate that anymore. This defendant has asked for a second chance. But you've heard testimony and evidence about the fact that he's had at least 2 previous probations. He violated his probation, the current probation, by committing this offense. You saw in that video, he was leaving the probation department. He just met with his probation officer before pulling out a gun and shooting somebody in the face. We had this back and forth discussion during jury selection about rehabilitation. Rehabilitation is great, but remember, it's one of those 3 goals of the criminal justice system. One of which is to punish, the other one is to deter. Punishment, deterrence, and rehabilitation. Rehabilitation only works if somebody's receptive to it, if somebody wants to be rehabilitated. 3 previous unlawful carrying of a weapon cases wasn't enough to rehabilitate this defendant. Okay? It would be nice if we can figure out what his malfunction is, what his defect is, that makes him recidivate, that makes him revert back to crime. But that's not our job. Not my job. I'm a prosecutor. Not your job. Your job is to see that justice is done and render the proper verdict in this case. It would be nice to know that, but whatever it is, it's in his nature, ladies and gentlemen. And insanity is defined as doing the same thing over and over and expecting a different result. And if you put this defendant on paper, as they call it, and with the promises and conditions to, I guess, I promise not to shoot somebody in the face again. That's all it is. It's a promise. He made the same promise when he was on probation before. The same promise not to commit a crime. Ladies and gentlemen, that's offensive as well. It offends me that he would come in here after committing this offense and look you in the eye and ask for probation. There are cases that lend themselves to probation. There are situations in defendants and circumstances that lend themselves to probation. A DWI, first time DWI, somebody who evades from the police, they didn't want to pull over because they were scared. Something like that, some property crime or something like that. There are those cases that lend themselves to probation, but it is offensive to ask for it in this case under these circumstances. And I just can't believe that he would even come in here with a straight face and ask you to do that. Ladies and gentlemen, you've got a duty to protect this community, to protect this society. You may not think that what you do in the way of your verdict makes that big of a difference to protect our society, but think about this. Had he been in jail for that previous offense that he was on probation for, then Hunter Freeman may not have been shot in the face. If you let him walk out of this courtroom, who knows what, if anything, he will do. He just doesn't get the message, okay? You also have a duty to Hunter Freeman, a duty to render a just verdict. And when I say justice, I'm talking about equity, something that is fair and on par with the harm that he has suffered. Letting this defendant just walk out of this courtroom, having just been minorly inconvenienced, is not fair or equitable when compared to the harm that Hunter Freeman has suffered. You heard of the long-term effects, having to recall that event over and over, the loss of hearing, the loss of his teeth. That pales in comparison to probation. This defendant, let me say this, 3 weeks from now, you and I, we're gonna go on about our business. 3 months from now, you will struggle to remember the names of the participants in this trial. My name, Mr. Burbank's name. 3 years from now, this will be a distant memory for you, for all of you. But 3 years from now, Hunter Freeman will still be dealing with the consequences. He'll still be reliving this. He will still have the physical impairments from this offense. 3 years, 30 years from now. So I submit to you that putting him on probation is not on par. It's not equitable. It's not justice. So please, I implore you, don't do it. Do not put this defendant on probation. And when I talk about the community, I'm not talking about some amorphous term, some term that doesn't really apply to actual people. You saw that video of Miss Jennings' 11-year-old son. He's a victim too, by the way. He saw all of this blood and the aftermath of this individual being shot. You saw how he looked, the look of fear and shock on that child's face. He's a victim as well. Anyone else who would have been on East Expressway that day, they were potential victims. Anybody that would have been in the backseat of the Suburban, they were potential victims. Just a few things for you to consider. I submit to you in your deliberations is you can consider all of the evidence, totality of evidence. You can consider those previous convictions. You can consider how evasive he was. I'm being generous about saying evasive. You can infer that he was just straight up lying to you when he said in all 4 instances he can't remember where he got those guns from or who he got them from. And in this case, that gun is still out there somewhere, waiting to rear its ugly head, and who knows, God knows whose crime, because it's going to get passed around again on the streets. So you can consider that. You can consider that in your deliberations and in your assessment of the punishment. And I brought the evidence of that urine incident in the jail. It's kind of, I will concede it's kind of trivial, but I brought you that evidence because even in a confined, controlled situation there with guards and everything, this man can't follow the rules there. He can't follow the rules on this stand, can't follow the rules of the court. What makes you think, you saw his demeanor up there, what makes you think he's gonna follow the rules of probation immediately? Okay? Don't be fooled. He wants to come in here, cry the crocodile tears, say the right words that I am convinced he practiced before he got here, and try to snow you into giving him a probation. And lastly, his demeanor. His demeanor, I think, is indicative as well. While he may have said the right things, you saw how he was toward the end of my question. I suspect that had I pressed him a little bit more, a couple more questions, the real Asa Jones was about to come out. You saw it. He was ready to go. And had I thought I had a little bit more leeway, I would have gone there with him too. But you saw it, you can assess that. And what I'm saying is, not to be mean-spirited, those are all things that you should and could consider in determining the appropriate punishment for this defendant. I'm just gonna briefly refer to my little chart here because I think it's helpful to see. We can talk about the punishment range, but I think it's helpful to actually see the punishment range. Probation, all the way up to life in prison. I submit to you, this is not a life in prison case. So let's just take that off the table. There are, believe it or not, more egregious cases out there that merit a life sentence. However, on the other end of that spectrum, for all the reasons I just said, this ain't no probation case either. So let's take probation off the table. Now you're left with 5 to 99. Even before Hunter Freeman took the stand, and he and I didn't confer about this and talk about this, in my mind, I already had an idea of what this case was worth, so to speak. And I was thinking that you take the top end of this punishment range off the table. Certainly, you based on everything I just said, you know where I stand on the bottom end of the punishment range. I think you take that bottom end of the punishment range off the table, given his priors, given the body armor. I almost forgot about the body armor. You can consider that. That's in evidence. Who drives around with body armor if you're not law enforcement? Take all that stuff into consideration. His priors, the body armor, the previous guns that he suddenly can't recall where he got from. I submit to you, and most importantly, the nature of the offense. And I'm not going to rehash the nature of the offense. People could have been killed. Other people could have been killed. Hunter Freeman could have been killed. That's why I submit you shouldn't consider the low end. That's why I think you get somewhere right here. And again, I never even talked to Hunter about what I thought the case was worth. But I think remarkably, Hunter and I are on the same page. I will concede, I was thinking probably around 35 is where I was thinking. He was at 40, but I think we're in the same, we're in the same ballpark. Uh, and I say that because again, equity, parity on par with what the suffering that Hunter had to go through for the next 30 or 40 years. Couple things. Whatever sentence you assess this defendant, the jury charge says that you can consider the fact that parole exists. There's some very specific language in there. I would invite you to look at that language about parole because it also goes on to say, well, think back. There is a possibility that no matter what sentence you assess, that this defendant would be eligible for parole, with having after doing half of his time, okay? There's that possibility that he can be eligible for parole. However, that jury charge tells you that's not guaranteed, and that's not something you can say specifically what happened to this defendant, okay? But you certainly can consider it in the existence of parole and the possibility of parole after doing half of his time. You can consider that in assessing your punishment on this punishment scale, in this punishment range. And another thing, Mr. Burbank and I do agree on the fine. I would suggest to you, you don't spend any time on the fine. A lot of jurors get back there and they get hung up and start negotiating about the fine. That fine's not gonna go to Hunter Freeman. Who knows what the state will do with it? I would submit to you that you don't spend, even if it gets paid, typically it doesn't get paid. But even if it gets paid, it's gonna go to the state, and who knows what the state will do to it. Sentence him within this range, somewhere between 25 and 50 years. Not because I say so, but because that is justice, ladies and gentlemen. That is both punishment, it's deterrence, and believe you me, it's deterrence. The jail will hear about this. The other inmates will hear about this before this defendant gets back to the jail. That's how it works. And also the general public will hear about it. Any other defendant who would even think of doing something so stupid and just reckless, hopefully will reconsider that punishment, deterrence, and while he's in prison, if he chooses to, he can take advantage of being rehabilitated. But that's what I'm asking you to do. I have faith in you. I trust you'll make the right decision because you did the right thing during punishment, during guilty innocence. And I'm asking you to do just that this time around. Thank you.
Thank you, Mr. Goldman. All right, ladies and gentlemen, that's all the evidence in the court's charge and closing argument. I'm giving the charge to the bailiff. She'll get you situated in the jury deliberation room where you will deliberate, and we'll be in recess until you reach a verdict on punishment. You guys can go back with the bailiff. All right, let the record reflect state's attorneys present, defendant and defense counsel are present. I've received a message that the jury's reached a verdict.
I'm sorry,
If, you can bring the jury in.
I'm sorry on these people that are in court not to be here. You and I spoke about this case, the legal side of it, and what can possibly happen. What are you asking Judge West to do today?
I think the only thing that can be done is the maximum sentence. I think that's the only way that any kind of healing can be done. From just on my end and from the 1,000 lives that were affected by this senseless tragedy.
Thank you, Chris. I'll pass it to Sean.
Any questions? Thank you. Let me call your next witness.
State called Boston Carr.
Go ahead.
Thank you, Your Honor. Mr. Carr, would you identify yourself for the jury and tell us what you do for a living? I mean, for the judge, and tell us what you do for a living, please.
All right, let the record reflect
My
the
name is
jury
Boston
seated,
Carr,
state's attorneys
and I
present,
live in
defendant,
Omaha,
defense
Texas.
counsel are present. I would
And
ask
I
the
work
foreperson,
for
has the
Pierce
jury reached a
Industrial and
verdict?
Industrial Sales
And is
Company.
it the unanimous
And how old are you,
decision of
sir?
all of the members
I'm
of the
22
jury?
years old.
Thank you. You can hand it to the bailiff.
How did you find out that Camille had been killed?
I was asleep and my dad.
We, the jury,
busted
having
into
found the
my room,
defendant, Asa
and
Joseph
it was
Jones,
about
guilty of
4:30,
the
5
offense
o'clock
of
in the
aggravated
morning.
assault, assesses
And
punishment at imprisonment
I
in the
remember
Texas
waking
Department
up
of Criminal
and he
Justice
just
for a term
said,
of 7
The
years and
girls
no
died in an
fine.
accident.
You can have a
My
seat.
first thought was that they had to be okay.
Does either party wish to
There was
have
no
the
way
jury
something
polled?
No, Judge.
that could happen.
All right, then, any reason not to
And
pronounce judgment at
I
this time?
immediately asked, "Are they okay?" what hospital
Then
are
at this
they
time,
at?
Mr.
You know,
Jones,
did
in
they-
accordance
what
with
ER are
the
they
jury's
in?
verdict,
And all my
again, I've
dad
already
could say
found you
was
guilty, and
they
at
didn't
this
make it.
point, you're
All I
now
could say
sentenced
was
in
no.
accordance with that
Just
verdict to a
no,
term of 7
no.
years in the institutional division of the
And
Texas
I
Department
jumped
of
out of bed
Corrections.
and
You do
I
receive
still
credit
just
on that
couldn't believe
sentence
it.
for any time that
I
you've
just-
been in
there's no
custody
way.
that the law gives you the
And I
right
got
to
dressed as
receive.
fast as I
You've
could.
been
And
handed a
I
couple of
ran
documents.
downstairs and
One is a certification
I
of
didn't
your
know
right
what
to
I could do.
appeal.
I
You
just
do have a right to appeal. and
thought
you
there
can
was
talk to Mr.
something
Burbank
maybe I
about
could
that.
do.
You've
And my
also been
dad just
handed
told
a
me, he
written
said, "Bubba,
admonishment
there's
regarding
nothing
your
you can do.
ineligibility to
There's nowhere
possess
you
a
can go.
firearm or ammunition.
Can't do anything."
Because of the judgment
And
entered
since
against
this
you, you're
happened,
ineligible
how's it
under
affected
Texas
you
law
all?
to possess a firearm or
I had
ammunition.
begun building my
If
life
you have any
with
questions about the
Camille
laws that make you
and my
ineligible
life
to
plans
possess a
and
firearm or about how
our
long
life that we
lasts,
were
you can
building
also talk to
together.
Mr. Burbank.
We had just
Mr.
begun to
Burbank.
build together. Was just taking off, and
There, because
one
he was
thing
found
that I
guilty
thought I
of
had
the
done right in my
indictment
life
as
was
charged,
deciding
there is
to marry
that
Camille.
affirmative finding of the possession of
And
the deadly weapon, so that will
with
go
that
into
gone,
the
I just-
judgment as well.
I feel so
You'll be
lost
remanded to the Jefferson
in,
County
like,
Sheriff's
this
Department
life
until your
that I was supposed to
transportation
have
to the
has
Texas
been taken
Department
away
of
from
Criminal
me.
Justice.
I'm asking the same
You
question.
can now
that
go back
I
with the
asked
bailiff.
Chris.
Ladies and
What
gentlemen,
do you
I'll
want
come
to
visit
see
with
happen
you
here
in just a
today?
minute.
Full sentencing underneath the law, that's possible.
And that's actually not enough.
Excuse y'all.
Thank you,
Not
Mr.
saying-
Coleman. Thank you, Mr. Burbank. Y'all are both excused. The
Yes,
court
sir.
I
will
don't
be,
believe
you can
it
go to
is.
the back and then I'll let you know when you come through.
Thank-
All right,
thank
court
you,
will
Mr.
be
Carter.
adjourned and I'm gonna come down and visit with you, let you know all your instructions and we'll let